I'm Roop Gill, and I'm the head of our Elder Law and Special Needs Division here at Walker Lambe. And I'm going to talk about some elder law issues today.
What is elder law?
What is elder law? People ask that all the time. Well, what elder law isn't just older attorneys practicing law, okay? Elder law is planning for disability. And as you know, long-term care policies cost a lot. Sometimes people can't afford them, but a lot of times we find that clients have a disqualifying condition. You know, they've had cancer, they've had a minor stroke, they won't qualify for any long-term care policies. And if you end up in a nursing home, you're looking at anywhere from $6,000, $7,000 to $15,000 a month in long-term care costs. So with elder law, we try to protect clients' assets as well as get them qualified for the programs that are out there. And there's three main programs out there for elder law for paying for long-term care costs. There's a North Carolina Special Assistance Program, which will, if you qualify, which will pay for long-term care expenses at assisted living facilities. You've got Medicaid. A lot of people have heard about Medicaid. It's a federal program implemented at the state level, implemented differently in every single state, and that will pay for long-term care at nursing facilities, what we think of as nursing homes. And then you've got VA aid and attendance pension benefits. I mean, if you're a qualified war veteran, so if you were in the military on active duty at least 100 days, and it was during a time of war, World War II, Korea, Vietnam, then you may qualify for VA aid and attendance pension benefits. For clients I've met with before, I want you to know that there have been massive changes in the VA aid and attendance pension benefits program this past November. So if you're thinking about doing any kind of planning for that, come speak to us.
Do I need elder law?
That's a good question, and a lot of people ask that. And the answer is, it's a good lawyer's answer, which is it depends. It depends on whether you've got a long-term care policy. It depends on your health. There's a lot of factors involved. But what I can tell you is that if you have any type of, health issues, either physical or early memory issues, early dementia, please come and speak to us, because the longer time that we have to plan, more of your assets we can protect, because it takes time sometimes to protect assets.
How do I know if I need it?
Well, that's a good question as well. If you have any physical issues, or your spouse has physical issues, or you're starting to have memory issues, or your loved one's having memory issues, call us and come in for a consultation. Like I said, the more time that we have to get ahead of this, the more assets we can protect. I can tell you that if you've got any of those kind of issues, the first thing we're going to talk to you about is what we call a Medicaid general power of attorney. There's a misconception that all general powers of attorney for financial matters are the same. The fact of the matter is they are not. Okay? If you just came in and had estate planning done with us, you receive the statutory general power of attorney in North Carolina. And the statutory general power of attorney limits what your agent can do on your behalf. There's a good reason for that, because you don't want your agent running off with your money. So it limits any gifting that your agent can do to the federal gift tax amount, which is currently $15,000 a year. Well, that really limits what can be done to protect assets for someone who later on, has a massive stroke, and is incompetent. So there's not a lot that a spouse can do with that general power of attorney as far as protecting assets for long-term care expenses. So we recommend a Medicaid power of attorney, which has broad gifting powers. There's still some safeguards in there so that somebody doesn't run away with your money, okay? But it will allow spouses as well as your children, your agents, to protect assets and still get you qualified for VA aid and attendance or Medicaid or the Special Assistance Program. Let me give you an example. Let's say you've got a husband and wife, and the husband had a massive stroke. They don't have a long-term care policy, and even if they could afford it, it's too late to get one. He's incompetent, And let's say we did planning and protected all their assets. Well, their house is a non-countable asset for Medicaid. But if the house is titled like we normally see with a married couple, which is in joint tenancy with right of survivorship, tenancies by the entireties, then it's still not a countable asset for Medicaid, but you've got to protect for other factors down the road. For example, we get that husband qualified for Medicaid. House is non-countable. He's in a nursing home for like 4 or 5 years. In that time frame, the wife passes away. If the house is in joint tenancy with right of survivorship, it goes to the husband. It's still not a countable asset for Medicaid because he has an intent to return home, whether or not he ever will. But when he then passes away, that house will go through probate, and the state of North Carolina will put a debt against that house for the cost of his care for those 4 or 5 years that he was in a nursing home. One way under current law to avoid that is once we get the husband qualified for Medicaid, the wife with the Medicaid power of attorney transfers the house into just her name. There's no penalty for transfers between spouses under the Medicaid rules. Put in the spouse's name, then we do a new estate plan for the spouse where if she passes away first, the house and everything else goes to the kids. So in the same scenario, if she passed away first, the house, all the other assets go to the children. Later on, when husband passes away, there are no assets in his name, so there's no estate recovery because there's no assets. So that's just one simple, scenario where long-term care planning, just a Medicaid power of attorney did so much. Hi, Roop Gill. I'm the division chief for our elder law and special needs division here at Walker Lambe. And I'm going to talk a little bit about special needs trusts. We get questions all the time about special needs planning. If you had planning done previously and you're leaving assets to children, grandchildren, family, friends, over time, one thing that we know that does happen is changes happen. And if from the time that you had your estate plan done, now you've got a beneficiary who is now special needs. They had a car accident, stroke, or something like that. And now, if they're special needs and they're on any kind of public assistance, SSI and or Medicaid, then leaving assets to them outright could kick them off that program. So anything over $2,000 in their name is going to kick them off of most of the public programs that are out there. So we recommend here at Walker Lambe that if you're leaving assets to anyone who's a special needs beneficiary, then leave it in a supplemental needs trust, which is a type of a special needs trust. The assets can still go to that child, for example. It can be used to supplement whatever that child is receiving from the government without it being a countable asset. And when that child passes away, you select who the beneficiaries are for whatever money is left in that supplemental needs trust.